To the fourth case on this morning's docket. That is case number 106102, State of Kansas v. Anthony Waller.
Good morning. May it please the court. Mr. Schroeder. Mr. Waller was charged with felony murder, aggravated
Excuse me,
kid.
counsel, since we're video streaming live, could you state your name and appearance for the record
I
again?
apologize, Your Honor.
No problem.
David Roberts, Hutchinson for appellant.
Very good, thank you.
Thank you. Your Honor, Mr. Waller was initially charged with felony murder, aggravated kidnapping, and aggravated robbery. He was convicted of the felony murder charge and aggravated kidnapping. I think the facts need some to be repeated at some length. Excuse me. In the spring of 2010, Mr. Waller's apartment was burglarized. Mr. Waller happened to be across the street at the time working. He saw his downstairs person lived downstairs from him, downstairs neighbor, Mr. Coons, leaving. He filed a police report at the time. He alleged that Mr. Coons was the potential burglar of his apartment. Mr. Coons was contacted. He did not acknowledge doing that. He denied that. On the evening of 9 April 2010, Mr. Dela Cruz and Mr. Grissom dropped into Mr. Waller's apartment. They were uninvited. They both were high. They had taken multiple drugs, had been on multiple day benders. Shortly thereafter, Mr. Coons, the downstairs neighbor, came and advised Mr. Waller that Mr. Coons was aware of who had actually burglarized his apartment. And Mr. Coons had made arrangements for this person to come to Mr. Coons' apartment and surrender the property back to Mr. Waller in an effort to avoid involvement by the police. Mr. Coons then invited Mr. Waller to come down to his apartment to wait for this person to arrive. Mr. Waller obliged that invitation. Mr. Dela Cruz and Mr. Grissom also went with him. They waited down in the apartment, Mr. Coons' apartment. Sometime thereafter, and Mr. Haynes arrived. When Mr. Haynes arrived, Mr. Waller walked up to him and said, "Are you the man that burglarized my apartment?" or words to that effect. The first thing that Mr. Haynes did was to double up his fist and take a swing at Mr. Waller. Mr. Waller avoided the blow. Mr. Haynes then grabbed his arm, and Mr. Waller told him to let go. He refused, so Mr. Waller then punched him once in the jaw. He was stunned, he fell back, and eventually fell to the floor. Mr. Waller stood there as Mr. Coons walked up and then began to kick Mr. Haynes in the head.
These are all your client's version of the facts.
That's correct, Your Honor.
Obviously, there's other versions of the facts.
That's correct, Your Honor.
What issue would you like to focus on here, based upon either your version or the state's version? Clearly, there's two different versions. One had your client hitting Mr. Haynes with a 2x4.
Yes.
Multiple times, and kicking and engaging in the act, and Mr. Waller denies that, so we have a dispute about the facts. But why don't we get to the issues here, and what issue would you like to focus on?
Well, Your Honor,
issues?
with respect to the issue of the legal question, after this case was decided, this court issued State v. Berry, which said the provisions of 223413 equally apply to the crime of first-degree murder, also felony murder, and this court decided that the Berry decision applied to all pending felony murder cases, which you stated that a case was not final until the conviction is occurred.
What effect is the 2013 statute that was passed by the legislature that says that it's procedural, that the change in the act is procedural, and that there's no longer any lesser included instructions required in felony murder? What impact does that have?
Well, Your Honor, are you referring to KSA 5109A?
I'm referring to, yes, with the statute that no longer requires and says that there's no lesser included to felony murder.
Well, Your Honor, this is the only issue I can stand on this one. This is all I have, Your Honor, that the law was made. If this court entered that decision subsequent to the fact and
But the court didn't, the legislature did.
I understand that, the Berry decision. And looking at 215109A, subparagraph B1, a lesser degree of the same crime. And that previously had included under 5109 B1, no lesser degrees of murder in first degree under subsection A2 of 215402. So we would argue that the Berry rule should apply, and he should be allowed a new trial on that basis. Here, I've also raised other issues. I think my brief speaks for itself on those. If you have any questions about those, I'd be more than happy to address them.
Do you have any further presentation for us, counsel?
No, Your Honor.
Okay. Any further questions of counsel? Thank you.
Good morning. If it pleases the court, I'm Keith Schroeder. I'm the Reno County District Attorney on behalf of the state of Kansas, the appellee in this case. I was trial counsel in this matter, so I have some knowledge of the facts. I guess to begin with on the first issue and the issue that we're really dealing with as to whether or not there was error by not giving lesser included offenses. Prosecutors around the state were somewhat of a disadvantage because when this case was tried, the law for a long time had been you don't give lesser included offenses on first degree murder under the felony murder doctrine. And then the Berry case.
Not categorically. There was an exception.
Okay, that was the general rule.
Right.
There were exceptions. And then the Berry case came down. And then there was the legislative amendment under KSA 215109 that happened. And then the Wells case. All of this has happened
Lots of movement.
well after this case is submitted to a jury and tried on the case. So the 6-day jury trial is now looked at through the lenses of those events. I guess without, first of all, looking through those lenses, I understand the status of the law right now. This court has held that the exception under 215109 subsection E still violates due process as far as an ex post facto, and that it doesn't relate back under the Wells decision. But without going into that, if you look at the basis for requiring a lesser included offense, the state submits the defendant failed, that there was not evidence, even viewed in light most favorable to the defendant, that would have justified or supported the giving of a lesser included offense. This was an ambush. It was a premeditated ambush in which persons were wearing latex gloves. The victim was drawn to the residence under the guise of a drug deal. He was robbed of certain items. His earrings were missing. His wallet was missing, which was later found stuffed down a police car back seat in Wichita. His car keys were taken at one point. His car was actually driven to his house, and then his body was stuffed into the car and it was left a few blocks away. There was excessive force. The only person that says that there was a physical altercation of any kind is the defendant Waller. All the other witnesses say it was a clear ambush in the dark. Excessive force, lack of provocation, none of the things that you would look at for lesser included offenses when you view the evidence are sufficient for the giving of a lesser included offense instruction. When you look at the evidence in the light most favorable to the defendant, and I was looking at the appellant's brief on page 16. I don't think we're supposed to refer to it, but he has a recitation of the facts there, which talks about the fact that at no time did Mr. Waller engage in this strangling or hitting. It's essentially a thing of, I didn't do anything. Other people did it. And in that situation, irregardless of Wells, irregardless of Berry, a lesser included offense instruction is not warranted. And so that's the state's position, is that we shouldn't have given one to begin with, unless the court wants to inquire into my personal opinions about Wells, and as you know from the Prine decision, and my extensive arguments to the court about ex post facto laws going back to the 1700s, that's my primary issue here, is that even despite all these other rulings, a lesser included offense instruction was not warranted.
No,
Why-
I'm sorry, go ahead.
Why isn't the legislature's declaration that felony murder does not include lesser included offenses constitute a definition of the crime? In other words, beforehand, felony murder could have lessers. Now it can't. And why isn't that a change of the definition of the crime? You understand what I'm saying?
It's a change. Whether it's a substantive or procedural change.
Well, my question is, doesn't it define the crime?
I would argue it does not.
Okay.
It does not change the elements. It does not change the punishment. It does not change the quantity of proof. It does not change the degree of proof. And that's, going back to I think it was Dover versus Florida in 1977, the United States Supreme Court talking about a change in the law that affects the substantive parts of the charged crime. I mean, they're very specific. If it changes the substance of the charged crime, and I understand what you're saying is that does in fact change that. And with all due respect, we believe the state submits it was procedural, not substantive. But we realize that decision's already been decided.
Let's visit about that for just a minute. That procedural versus substantive distinction goes to retroactivity,
Yes.
not to ex post facto. And once the legislature's opined on retroactivity, which it clearly did in the 2013 amendment, then we don't need to examine procedural versus substantive anymore.
Well, it was viewed that way in Wells as far as.
Now, Wells talks about whether it's retroactive. And at the point Wells was decided, which I have some familiarity with, as you're aware, that was the question: is it retroactive? And the legislature had not yet opined on that. Now the legislature has. That dispenses with the procedural versus substantive distinction, and we move on to whether it violates ex post facto or due process. That's the analysis. Wouldn't you agree?
I would agree.
Thank you.
I'm slopping it together in a bad way, and but it's the state's contention that law does apply back to this case. I think the court disagrees with the state on that, but
It may or may not. That's what I'm trying to get at. It may or may not. I think Wells is a distinct case.
and I kind of argued that to begin with on my argument. I structured it saying, here it is. This is what they held, and I underlined and bolded it. But clearly, irregardless of that argument, we believe that even if you look at the analysis for giving of lesser included offenses, they weren't warranted in this case. There was no error.
That's the heart of your argument.
Because no jury could reasonably have convicted of anything other than first-degree murder.
When you
is
look
your
at the
position.
evidence-
Is that right?
When you look at yes, sir. When you look at the evidence in a light most favorable to the defendant, he was saying, I didn't do anything. I acted in self-defense once, and I backed off, and other people did this. He denied his involvement. He was not. It's not as though he said, yes, I did this, but there are reasons or justifications that would warrant a lesser included offense.
Any further presentation, counsel?
The remaining issues, I will leave on the brief. Again, it's just the prosecutor in me that's when I see issues about prosecutorial misconduct as far as the general things, always kind of ruffles your feathers, but I think I adequately covered that in my brief. I believe every one of the comments or questions that were asked were supported by the record. For example, one question, I'd asked a detective or a witness, or maybe it was the coroner, as to whether or not the victim had been sexually assaulted. And some indication as to why would that be asked. Well, he had been found stuffed in a car and his pants were missing. He had no pants on. And so that was, had he been sexually assaulted? And the answer was no. I don't believe that rises to prosecutorial misconduct or somehow implying that there had been a sexual assault in some way.
The question of the outburst by Grissom
Yes.
during believe it was his direct testimony, I can't remember his direct or cross, but there was the outburst by Grissom in which he obviously became emotional. The court recognized that, took a break, but during that time in which the jury was being escorted to the jury room, some of the outbursts continued. And then at the close of the evidence, defense counsel characterized it in a way that wasn't characterized during the time of the outburst or thereafter, that the jury heard some of this, at least the man up part.
Well,
Anyway, what exactly occurred when the bailiff came back and said, no, everything was muffled, we couldn't hear it? And that was what the defense counsel wanted in terms of some.
I have to be careful with remembering what is in the record with my personal memory of the event. And unfortunately, this court is in a position where you're sitting in the courtroom with the emotions and you see the witness begin to
Right, I understand.
wrap around the axle, and you can see it coming, and the judge saw it coming. And several times it admonished him to kind of calm down. And then it got to the point where the judge finally said, and I think I quoted this in my brief, told them we're going to take a break and asked the jury to leave. And then turned to Mr. Grissom and said, you're doing fine, trying to calm him down. The jury had exited the courtroom and the door was shut. And that was when the explosion happened as to Mr. Grissom confronting the defendant saying, you need to man up and admit what you did. And at that point, quite frankly, I took him out the back door to the judge's chambers and had him sit on a couch there and tried to calm him down. There was some question raised as to what the jury had heard, if they'd heard him yelling, man up, after the door had been closed and they were back in the jury room. The judge did several things in this case. He asked the bailiff specifically. He made a record of what his recollection
Well, I
of
think
events
defense
were.
counsel asked him to ask the bailiff.
Well, the bailiff was asked.
Right, exactly.
And the bailiff was asked, and that's in the record, and it's cited in my brief. And the bailiff said we could hear some yelling or something. We couldn't make out the words. That's what the bailiff said. Then when the judge brought the jury back in, I think he gave some type of an admonition to them, some type of admonishment saying, don't let this influence you, or it might have even, I think he may have even gone a little bit further.
I believe the record indicates that he had the jurors raise their hands.
Yes, page 24 of my brief. That was the last question she asked. You are hereby directed by the court to disregard any statements made by the witness following that, which would be at the point he'd had the jury leave. And then it says, by raise of hand, do you all believe you will be able to follow the order of the court and do not consider anything you heard following that in your consideration of the case? And then he said, all the jurors have answered in the affirmative. Proceed, Ms. Zygtema. So he addressed it that way. We think the court did everything it could within its discretion to make sure that didn't influence the jury. There was no indication they heard anything other than raised voices. We don't believe that rises to the level that would warrant a reversal of this conviction.
Any more questions of counsel? Any more presentations?
Not there any other questions.
Thank you both for
Thank you
your
very
arguments this morning. Court will take this matter under advisement.